Welcome to our channel and hence to our company. Indeed, based in Lomé, Togo, Fathers Afrique is a company of business, intermediation, and management. We work in the field of public tender contracts. We also intervene in the field of custom declarations, outsourcing, investment, and the financing. Our partnerships depend altogether on your business needs. Okay? Our goal is to provide you with information on business opportunities and how to best manage them here in Togo and hence in the West African sub-region. Today, we are going to explore together the field of tenders in Togo. I'm going to explain to you how the mechanism of public procurement and public service delegation works in our country, Togo. So, Excellencies, ladies and gentlemen, let's begin. It's my great pleasure and honor to welcome you again on our channel. Well, among the many directorates of the Permanent Secretariat for the follow-up of reform policies and program and financial programs located in the Ministry of Economy and Finance, abbreviated Permanent Secretariat, there is one that deserves a close-up. This is the Directorate for Financial Policy Coordination. We will be talking about it because of its crucial role in the procurement process. The aim is to make you understand that the award of public contracts is not a result of coercion, that is obeys a rigorous and, I would say, complex mechanism. The third question you will probably ask yourself is how to understand in a language accessible to the greatest number of people what the Directorate for Financial Policy Coordination is. What is its role in the awarding of public contracts? Simply put, what exactly is it, right? You know, in simple terms, the Directorate of Financial Policy Coordination is a structure within the Permanent Secretariat which is responsible for managing all procurement procedures. This goes from the call for tenders to the conclusion of the contract, to the award of the contract, to the approval by the Ministry of Finance, and if necessary by the President of the Republic. So, this coordination includes the Department of the Public Procurement Management Unit and the Department of Regulation. And this Department of Regulation has within it two services, namely the Internal Audit Service and the Legal and Contentious Services. Now, we know that in Togo Republic, there is a code of public contracts and public service delegations. What is the purpose of these codes, often abbreviated as Code of Procurement. Let me go back a little. The Code of Procurement was adopted in November 2009. It should be noted that in 2009, the Republic of Togo has to take very courageous decisions with the support of development partners, because certain weaknesses were noted in the public procurement management system, weaknesses that were linked to the control instruments. Others were related to the remedies available to bidding companies. Others, finally, were related to the regulatory procedures. Thus, the Republic of Togo had to adopt a public procurement code to enable it to promote major investment and good governance. The promotion of financial orthodoxy in the management of public funds was necessary. It is therefore in these circumstances that the public procurement code was adopted. Because in the past, it was noticed that there was some confusion between the awarding bodies, the control bodies, and a certain failure in terms of regulation. So, the Code of Procurement was adopted to put an end to such confusion. The Code of Procurement provides then the legal security that was expected by development partners. These partners include the World Bank, the European Union, the African Development Bank, the French Development Agency, and so on. So, the Public Procurement Code that we are using today, which was adopted in November 2009, secures the procurement procedures. It means international requirements for public procurement, okay? In particular, it makes a distinction between the different bodies, the procurement bodies, the control bodies, and the regulation. So, you have the contribution of the procurement bodies constituted by the contracting authorities. The mechanism of delegated project management for each part involves the permanent secretariat. You have the control body, which is the National Directorate of Public Procurement Control. It gives a non-objection opinion for the award procedures when it comes to call for tenders, or it gives a special authorization when it comes to recourse to mutual agreement, also called contract concluded by direct agreement. And finally, you have the Public Procurement Regulatory Authority, which intervenes to regulate the procurement system. This authority really allows tenderers companies, when they are wronged, to have a recourse. This authority intervenes in a way as a jurisdiction which rules on the rights that have been infringed. So, you can see that the contribution of the Public Procurement Code is immense and gives satisfaction to development partners. Okay? So, we now have a code that highlights the major general principles of public procurement. If you don't mind, I would like to pick up on an expression I used earlier, that is project management. We are talking about the delegation of project management. What exactly is this? In order to address these points, it is necessary to go back to the general principles of the law regarding public procurement. What is public order? When we look at our procurement code, it strictly defines the intervention of the state in terms of procurement control and monitoring of execution. The field of application is, on the one hand, public contracts, and on the other hand, public service delegations. So, what is a public contract? Well, a public contract is a contract concluded for valuable consideration between contracting authorities, in particular public authorities, and public or private persons. And these contracts meets the needs of these contracting authorities in terms of contracts for works, supplies, services, and intellectual performances. Now, in these environments, the Permanent Secretariat intervenes. The Permanent Secretariat intervenes in particular in the mechanism of delegated project management. What is then the delegated project management? Well, the delegated project management is a legal mechanism which allows the states, via a particular structure, to be able to award contracts beyond a certain threshold. Okay? Therefore, beyond a certain threshold, which is set by the decree relating to the award threshold, control, and approval. Above these thresholds, the Permanent Secretariat will intervene as official to place the order in the name and on behalf of the sectoral ministry. You understand? And when it places an order in the name and on behalf of the sectorial ministry, it must respect the main general principles of law on public procurement. These main general principles are freedom to bid, and therefore the freedom of access to public procurement, and the principle of equality between bidders. The principle of equality is a very important principle in the Public Procurement Code. Indeed, all bidders must be treated equally. It is the corollary of a major principle in administrative law, which is the principle of equal access to public services. There is no different distinction between the different entities that bid in full transparency. The sides are treated in a competitive and above all egalitarian way. Now, I beg you asking yourself the question, when an order is not public, what is it like? We are talking about public procurement. It is in opposition to what? Well, when the order or procurement, if you prefer, is not public, it will be a private procurement, because a public order involves public funds, and only those entities of the states that are clearly defined can place public orders. The other important question would be, is it possible for a private company to have recourse to the Permanent Secretariat within the context of public contracts and public service delegation contracts? Well, to answer this question, we must go back to the stage of intervention of public order. The procurement code is precise on these points, believe me. The procurement code sets in motion the procurement bodies, which are made up of the contracting authorities, the control bodies, and the regulatory bodies. The question here is, which state entities can award public contracts and public service delegation contracts? Because when we talk about public procurement, we have two components: public procurement as such and public service delegation contract. In application of the Public Procurement Code, only the contracting authorities can award public contracts. We are the contracting authorities. Who are the contracting authorities then? Well, as far as the state is concerned, the contracting authority is the sectoral ministry. Therefore, the ministry awards public contracts in the name and on behalf of the states. When we are in the context of a contract that is going to be awarded by a department, it is the president of the departmental council who becomes the contracting authority or project owner. Then, when we are in the presence of a public establishment of an industrial and commercial nature, and more precisely of an administrative nature, at that time it is the management director. When we are in the context of a public order emanating from the municipality, it is the mayor who becomes the contracting authority. And as far as companies are concerned, and particularly companies in which the state has a majority stake, at that point, it is the managing director who will place the order, and more precisely, the chairman and chief executive officer. But in this case, we will have to be in a predominantly state-owned company, okay? So, to fully understand, you have to know that those who have access to the permanent secretariat are ministry, departments, municipalities, state companies, etc. That's right. In application of the Public Procurement Code, it is clearly stated that the contracting authorities, therefore, among those I have mentioned, place the others. They delegate the project management to the permanent secretariat when the order reaches a certain threshold, which is set by the decree on the threshold for award, for control, and for approval. So, below this threshold, is it the ministry that manages the projects? The answer to this question is clearly yes. Below this threshold, it is the sectoral ministry which directly manages the projects in the procurement and implementation monitoring procedures. Okay? Now, it will be crucial to know what are the different modes of procurement, right? Well, there are two modes of procurement, which is not an innovation of the public, of the Public Procurement Code. From an international point of view, public procurement is done by invitation to tender or competitive bidding, if you prefer. In fact, that is the general principle. So, they put in competition the different bidders, that is to say, the companies that have the capacity to award the contract. Then you have the mutual agreement, also called direct agreement. In reality, direct agreement is an exception. Therefore, a contracting authority can only resort to direct agreement under conditions strictly limited by the Public Procurement Code. since the principle is the call for tenders, the competition, right? And the exception is mutual agreement. The mutual agreement, which we also call direct agreement, is limited. It is used in cases of emergency only. The contracting authority does not have the time to call for tenders to put several companies in competition, because there are strict deadlines that must be respected in the competition, in the analysis of the size, in the request and obtaining of the notice of non-objection. Each step of the product of the procedure is sanctioned by the obtaining of a non-objection notice from the General Directorate of Public Procurement Control. Sometimes the project owner or contracting authority does not have the time to respect all this procedure because there is a real emergency. At this time, the project owner can resort to the mutual agreement after having duly justified it. And it will be up to the General Directorate of Public Procurement Control to decide whether or not to authorize this recourse to mutual agreement. Okay? You have, for example, the case of contracts or other that require special expertise. And when they look at the marketplace, there is only one company that has this expertise, or only one company has the talent that the state needs. So at this point, we can also resort to mutual agreement. In the same vein, you have the so-called special contracts that affect national defense, state security, and very strategic areas. So you can see that the use of direct agreement is really limited. Remember, we said that the call for tenders is the rule and the direct agreement is the exception, right? So, who decides on direct agreement then? This question of who decides on mutual agreement is a very recurrent one. It is important to know that it is not the project owner, but the project owner will make the proposal to award the contract by mutual agreement. And it will be up to the National Directorate of Public Procurement Control to study the reasons and motivation. In particular, it will look at the technical complexity and assess whether the conditions are met. If this is the case, the contracting authority or the delegated contracting authority, as the case may be, when it is the permanent secretariat, may resort to direct agreement. The coordination service has a public procurement management unit. It has experts who are equipped in this practice of analyzing facts and in the preparation of bidding documents. Article 13 of Law number 2009-013 and public procurement and delegation of services deals with the general rules for awarding contracts. They are therefore the two modes which are defined. It says that open tendering is the rule and the use of any other procurement method must be exceptional. The exception must be justified by the contracting authority or project owner or the delegated project owner. The exception must be authorized beforehand by the General Directorate of Public Procurement Control. Therefore, we have two modes of procurement, which are the calls for tenders, and the mutual agreement. In terms of calls for tenders, we distinguish a series of calls for tenders. We have the international open tender. So, for complex work, an international invitation to tender is launched. At the international level, it calls on competing companies to compete with national companies. It can concern works, supplies, services, or intellectual performances. We have the national open call for tenders, for which the information is given to the national level only. Therefore, the advertising is done at the national level. All national companies with expertise in the field can indeed apply. We have a restricted invitation to tender. It is a call for tenders in relation to a certain urgency. So, a restricted call for tenders can be used. This means that selects the companies at the national level which have a proven expertise. These national companies are those that have already completed or carried out works, providing services, intellectual services, or supplies. They are therefore competent to be put out to tender. There you have it regarding the call for tenders. As far as direct agreement is concerned, the cases mentioned above provide us with sufficient information, right? Now, let's move on to the evaluation of the offers. Because when the conditions are in place, it is necessary to evaluate the technical and financial proposals of the companies. But before tackling the actual evaluation, we should first go back to the bidding document. Because it is from the tender document that the evaluation criteria of the offers received are defined. So, once the invitation to tender is issued, there is a certain period of time that is given to the company to prepare their bids. This period can vary depending on the case, between 20, 30, or even 30 days. Therefore, at the end of this period, at the agreed time set in the tender notice, the tenders are received. Of course, the bids can be received days before, depending on the availability, depending on the ability of the companies to be able to prepare their bids. Some companies can submit their bids far before the end of the deadline. On the last day set for the submission of bids, a list called the bid receipt register is drawn up. 1 hour after the bids are received, the public opening is held. Perhaps you have already had the opportunity to attend a public bid opening. Who can tell? Then, after this bid opening session, an evaluation subcommittee is set up. This evaluation subcommittee gathers the experts of the technical department who intervene according to each field. For example, for health, it could be a health expert. For public works, it will be a civil engineer. It could also be an electrician. That depends, okay? This depends on the subject of the call for tenders that has been launched. So, this subcommittee works behind closed doors, of course, with the participation of the project owner. Because the subcommittee is, I would say, tripartite. You have, I would say tripartite, sorry. You have the Directorate for Financial Policies Coordination, the Technical Coordination, and the Project Owner. These are the three members who participate in the evaluation of the bids. At the end of this evaluation of the offers, a report is drawn up. This report is signed by all the members of the analysis subcommittee. This report is submitted to the procurement committee. The latter, in turn, will decide on the conclusion reached by the evaluation subcommittee. The commission brings together the permanent secretariat, the representatives of the ministries involved in the project, the technical coordination, and finally, the technical committee. At the end of the works, the report of the procurement committee is sent to the General Directorate of Public Procurement Control. This is to solicit the non-objection notice on the award proposal made by the procurement committee. It is only after the General Directorate of Public Procurement Control has issued the notice of non-objection that the company, which is approached for the contract, is invited to sign the contract with the state. Okay? Finally, how can we summarize the procurement procedure? Well, you need to know one thing. The procurement procedure starts with the determination of needs. Therefore, it is the beneficiaries, sectoral ministries that determine the needs. And the Public Procurement Code makes it compulsory to be able to examine first the feasibility of the project. Once the needs have been determined and the procurement method has been decided, the second phase, which is the procurement phase, will begin. When it comes to a call for tenders, then we will have the third phase, which is to prepare the tender documents with the preparation of the specifications. Then we have the provision of the offers. This is where the bidding companies can have discussed to the bids and prepare the technical and financial proposal. Afterwards, when they submit their files, there will be a public opening session. This opening session allows precisely the respect of the competition. Each bidder must be aware of the financial and technical offers made by the other competitors. After the opening procedure, the analysis subcommittee will proceed to the evaluation of the offers. So, there is a whole body of case law regarding the analysis of offers. In the past, we used to talk about the lowest price offer. Nowadays, the practice is no longer just the lowest price offer, the lowest price offers. That's rather the most economically advantageous offer. So, they look at the equalization between the financial offer and the technical offer. And they opt for the bidder who makes the best offer from a quality and price point of view. So, today, what really counts is quality. Then, of course, when it comes to public fund, quality is required, not at an exorbitant price though. And for that, there are specialists to detect the right quality at the right price. There are specialists who assess and know the price list well. There are some in civil engineering. There are some in public health, so tenders concerning the acquisition for medicines. There are also some in area of service provision. So there is an equalization which is made to be able to retain the offer which is economically the most advantageous. Naturally, after this analysis, which is very technical and requires the use of technical mechanisms like experts, you have the phase of awarding the contract. When the contract is awarded, it is important to know that we are now going to enter into the execution of the contract. When we finish executing the contract, afterward there will be the delivery. So we follow the execution, but afterwards the work is developed, okay? Developed, okay? And when the works arrive at the delivery phase, we have what is called in project management the reception of works. When a work must be received, the company makes the request because it considers that it finished its mission. It makes the request of reception, and within the states, a special commission is set up. It is the National Commission of Reception of Finished Works. And this commission is under the leadership, the responsibility of the General Inspection of the states. It intervenes with the aspect of the contracting authority when the control mission which follow the technical execution of the project and with the permanent secretariat. Before accepting the finished works, the Commission ensures that the quality has reached the objectives that have been set by the contract. If this is the case, it is said that there is good execution. At this point, the National Finished Works Commission draws up an acceptance report. However, it can happen that there are reservations and that we realize that there are lots that have not been well executed. In this case, the Commission draws up a report with reservations, and a deadline is given to the company to correct these various reservations and remove them. Therefore, it is only when the company will have removed the reservation that the company can really have a final acceptance certificate. But there again, it is necessary to specify that when a works is accepted, we are in a matter of project management. The guarantee period is open. This warranty period allows the contracting authority to assess the performance of the work. Because in the period of guarantee of perfect completion, it can happen that the work behaves badly. And at that moment, the company which is assigned to guarantee must come back and correct the zero defect which has been noticed. So you can see that today we have a public procurement code that puts in place mechanisms that are very technical and quite solid. This mechanism requires a particular expertise that brings satisfaction to development partners. That is the last words. you have understood that the awarding of contracts is not a matter of chance, but that is obeys rigorous mechanism. Hope you got it all figured out. Okay? But there is a small question that the public often asks. The Permanent Secretariat carries out urban roads works and public lighting in the cities. However, these roads are sometimes in disrepair situation. So, who is responsible for their repairs? Well, it's true that in public opinion, when there is such disrepair and that initially the Permanent Secretariat has intervened, it is said it is the responsibility of the Permanent Secretariat. However, when there has been delivery, I explained to you earlier that there is a commission of reception of the finished works, which pronounces on the final reception. There is a report of transfer. The works is transferred to the beneficiary administration, which has the obligation to maintain and manage it. Thus, the mission of the Permanent Secretariat ends there. It said if in the context of a public service delegation, there is a delegation of public service for the management of the final works. This is one of the areas of application of the Public Procurement Code. As you know, we have contracts, but we also have the public service delegation. So, it is up to the beneficiary administration to manage the final works when it has been built in due form. And when a work is transmitted, there are still guarantees that survive the reception. You have, for example, the guarantee by work injury insurance. Therefore, in principle, the final manager of the work must see if there is a reproach to make to the ledger. He must see whether it is not possible in this hypothesis to bring into play a work injury insurance. Such insurance will be for the benefit of the person who authored the contracts. That's all for today. Thank you for your time. See you next time for a new capsule. Goodbye.